Good afternoon and welcome. My name's Kevin Igo, Managing Director of Professional Fee Protection. I'm delighted today to be presenting and introducing Phil Berwick. Phil, I've known for a number of years, a real expert in the field of tax investigations. And what we're going to cover today is the topic of tax discoveries, something that is a real-time issue for many of us now, where HMRC seem to be looking to stretch the boundaries somewhat. So firstly, Phil, if I could ask you to introduce yourself and tell our listeners a little bit about your background.
Good afternoon, Kevin. Thank you very much, and good afternoon to everybody else on the webinar. As Kevin said, and thank you very much for the invitation, Kevin, to speak to the session today. My name's Phil Berwick, Director of Berwick Tax Limited. My background is I used to be an inspector of taxes a long time ago. I spent 20 odd years working at different accountancy and law firms in London, dealing exclusively in investigations, disputes and inquiries. I set up Berwick Tax 7 years ago as a niche tax investigation boutique and handle on a day-to-day basis all types of inquiries, disputes and investigations from the revenue, and I provide a professional support service to accountants and work with accountants as well where their clients have got inquiry related issues.
Okay, great, thank you. So as usual, if anybody has any questions, please feel free to ask them in the usual way in the questions box. Phil has, of course, asked for as many difficult questions as he can get. We will be passing around or sending around a copy of the slides after the webinar was finished. So without any further ado, if I hand over to you, Phil.
That's great. Thank you very much, Kevin. In the time available today, even though it's an extremely important subject to tax discoveries, as Kevin said, and it's probably something that most people on the call will have come across at some point, and if they haven't done so, the chances are they will. But in the time available, there's only so much that I can cover. So it's an overview of the subject. I'm going to talk about what is discovery, provide a very brief history of discovery, looking at some of the relevant case law, look at some recent developments, which I think is going to give us all cause for concern with the direction of travel that the revenue seem to be going in. And then finally, just to wrap up, I'll be looking at some practical considerations involving discoveries. Whenever I lecture to advisors, I always like to have a practical angle, and hopefully everyone will go away with at least some sort of thought that they can take on board. So to start off then, what is discovery? I think the first thing to say is that we're probably all familiar and aware that there's a statutory framework when it comes to the revenue's conduct of inquiries. And the Revenues Manual says in the Inquiry Manual at 3201, wherever possible, HMRC should open an inquiry under the self-assessment provisions, which is all very laudable. However, there are times and circumstances where, for whatever reason, the revenue don't take the necessary action within the statutory framework for conducting inquiries. And in those circumstances, the discovery provisions are available to them. Now, one of the advantages of having a statutory framework for inquiries is that there are a set of rules that the taxpayer needs to follow, and also the revenue needs to follow as well. And that's the same when it comes to discovery, or at least it should be. And I've put on the screen, on the slides, the relevant statutory provisions covering discovery for income tax, capital gains tax, and also corporation tax. And there are similar provisions in relation to other taxes, including SDLT, for example. As you might expect and are probably aware, there's a huge amount of case law on the subject, and we'll look at some of the relevant cases. But what the discovery provisions permit HMRC to do is that they allow them to make an assessment to recover a loss of tax outside of the statutory inquiry provisions. The revenue don't have carte blanche to do what they want when it comes to making a discovery, or at least not accordance to the legislation, and there are certain conditions that have to be met. And as you see from section 29(1) of TMA, the legislation permits an officer of the board or the board to assess where an amount of income tax or capital gains tax ought to have been assessed but has not been assessed, or an assessment to tax is or has become insufficient, or that any relief which has been given is or has become excessive. And there are, as I say, similar provisions under at FA 98 in relation to corporation tax. So the first thing is that there has to have been an underassessment of tax or one of those other criteria. Where there's been an error or mistake in a return, and that's given rise to the underassessment of tax, HMRC cannot assess, they cannot make a discovery where the return was made on the basis or in accordance with prevailing practice. So for example, if you've got a situation where there's an issue as to whether a particular item is capital or revenue, if at the time the prevailing practice was that those items were treated as capital, as if the tax return has been prepared on that basis, then that should prevent the revenue from making a discovery. Where the defence is one of prevailing practice, the onus is on the taxpayer in terms of the burden of proof. So if required, you would need to demonstrate that the tax return was made on that basis. And you would need to do that by, for example, keeping a contemporaneous copy of whatever guidance it was that you relied on at the time that the tax return that was made, because it could be some time before the revenue make an assessment or make allege they've made a discovery, by which time the guidance could very well have changed. So where you have a situation and it could be that that there may be an issue in this regard, it's sensible to take a copy of the relevant guidance, file it away, and then if it does become an issue with the revenue, you've got a contemporaneous document that can be referred to. Where a tax return has been delivered, then one of two conditions need to be met, and that is the underassessment, etc., was brought about carelessly or deliberately by the taxpayer or a person acting on their behalf. Now we could spend the rest of the session just dissecting the wording of that particular subsection in terms of what does careless mean, what does deliberately mean, what is a person acting on their behalf, and we'll look at some of those points later in the session. But whether or not a particular taxpayer has brought about a loss of tax carelessly will depend on a number of circumstances. You would need to consider the particular facts of the case, such as the size and importance of the matter concerned. What is the underlying error? What advice did the taxpayer take or not, as the case may be? Who is the taxpayer concerned? If it's an individual, sophisticated taxpayer or not, what are their resources and capability to consider the issue, amongst many other factors as well. And the revenue are required to consider those various elements when forming a view on taxpayer behaviour. Whether they do or not is a different matter. And the revenue officer must be able to identify what behaviour they believe has brought about the loss, why they think it was careless or deliberate, as the case may be, and what evidence they have to support that conclusion. And then in terms of a person acting on behalf of the taxpayer, as I say, we'll look at some cases lately, sort of later, that consider that point. But briefly, in terms of whether or not a person is acting on behalf of the taxpayer, it's about doing more than just providing advice to the taxpayer. They need to take the steps that typically the client could do, so which could include completing a return, filing a return, entering into correspondence with HMRC, etc. And there's a commentary on that in the Upper Tribunal case of HMRC and John Hicks, which sets out some of the circumstances where it may apply that somebody is acting on behalf of the taxpayer. The other consideration where a tax return has been delivered is whether at the relevant time the officer could not have been reasonably expected, on the basis of the information made available to him before that time, to be aware of the under-assessment. And again, we could spend the rest of the session looking at those particular terms. And this in part comes down to when we're considering the information made available to the inspector, any information that's been provided to the revenue, for example, in the course of an inquiry, information that's been provided to the revenue on the tax return. For example, whether or not any additional notes are being included in the white space, such that may give some form of protection to the client against a disclosure allegation by the revenue. And I think one of the points to make there is that, and we'll see that as well when we come on to some of the recent cases, advisors need to be very careful when putting information in the white space and making sure that sufficient information is provided in the white space to protect the client against an allegation, a subsequent allegation of discovery by the revenue. And certainly when I speak to advisors on this, the tendency is to not give sufficient information to reduce the likelihood of the revenue subsequently making a discovery. I think one of the points here, of course, is that if you put quite a bit of information on the return in the white space, then that may lead to an inquiry. In a way, at least it's flushed the inquiry out and you can deal with it. But if the revenue don't pick up the return for inquiry and they subsequently allege discovery, if there has been a sufficient note made in the white space, that may be sufficient to protect your client. In terms of time limits and how long the revenue have got to make a discovery, I'm sure everyone's aware of the normal time limit where the revenue have 4 years after the year of assessment to issue an assessment, 12 years where that relates to offshore matters and transfers. Where the revenue have made a discovery, if they establish that the taxpayer's behaviour or the person acting on their behalf, if that was careless, the revenue have an extra 2 years to raise an assessment. And where they can establish that the behaviour is deliberate, the revenue have 20 years to make their discovery. An important point here is that absent an admission or confession by the taxpayer, the onus is on the revenue to determine and establish, potentially to the satisfaction of the tribunal, that either the taxpayer or the person acting on the taxpayer's behalf was careless or deliberate as appropriate. So it's an extremely important point, that distinction between the 6-year assessing period and the 20-year assessing period, and certainly when you have a particular set of circumstances, the client will certainly have a view as to whether or not their behaviour was careless or deliberate, if they haven't taken reasonable care. We as advisors may have a different view, and the revenue certainly are likely to have a different view. And the revenue starting point can tend to be, they assume that the behaviour is deliberate, and then they work down from there, because that gives them longer to issue a discovery assessment. And as you can see from the slide, there are similar provisions in relation to the time limits for corporation tax at FA 1998. But for corporation tax, it's only the 4, 6 and 20-year timelines that apply.
If I could just ask a couple of questions at this point, Phil.
Yes, absolutely. I was going to say, if there are any questions, have I sent everybody to sleep? So
And Ari's asked, in the case of a taxpayer who filed a tax return 4 years late, is it correct that as long as the behaviour is agreed as non-deliberate, HMRC would only have approximately 2 years to raise the discovery assessment, being 6 years from the end of the tax year?
So the tax year is the tax return is filed late.
Yes, the tax return is filed 4 years late. So how does that affect the assessment deadlines?
The revenue still have the 6 years where if it's careless, then they have 6 years from the date at the end of the year of assessment yes.
Okay. Keith makes the point, the issue of behaviour always seems to be a contentious one. HMRC seem to be convinced that a taxpayer has acted at least carelessly and often deliberately, and they are hard to move from that. Can you comment on how to deal with that?
Well, I think that's an excellent question. Was it Keith? Was it Kevin?
Keith, yeah.
Yeah, excellent question, Kevin. And I suspect that everybody on the call was probably thinking along the same lines, because I know certainly when I get involved I'm asked to get involved in cases, then inevitably the revenue have started from a position that it was deliberate, and I think how you respond to that, Kevin, is that you just need to look at the facts. You need to go through the issues with the client, establish the facts in terms of what's happened, all those factors that I mentioned at the start of the session. How has the error occurred? What are the relevant circumstances? There may be circumstances not related to tax, for example, the client's health. Maybe there are some mental health issues, maybe there are some domestic issues that have impacted on the client's behaviour, that can be put together to form a coherent argument to try and persuade the revenue that they are wrong in their assessment. And I think it's fair to say that certainly when I'm dealing with a case like that, I will want to thoroughly interview the client to establish the facts, make sure there isn't anything that they're holding out on before then going off and liaising with the revenue. And I would certainly want the revenue to explain in detail why they think that the taxpayer's behaviour was either deliberate or careless. And once the revenue have nailed their colours to the mast in that way, then I think that can help in terms of starting to unpick the revenue's position. and I think a further point to make on that, Kevin, is that ultimately a lot of cases involving discovery end up at the tribunal. But my view is that it should certainly be better if you can agree the position with the revenue, and rather than waiting to go to the tribunal or ADR to make those various points to support your client's position. I think it's sensible to have a dialogue with the revenue, say get them to put their case first, and you can then put forward any relevant mitigating factors. But ultimately, the revenue may not agree. They may stick to their view, and if that is the case, you may then have to go down statutory review, ADR, and ultimately the tribunal. But another point there is it might also be worth getting a second opinion, and this is something that comes up time and again when I speak to accountants. There's an acceptance and an admission by them that maybe they're too close to the case. They can't look at the case objectively, and sometimes just getting in another pair of eyes to review the facts and to form a view, that may also help as well in terms of and then giving some further direction to go off to the revenue. But 100% agree, Kevin, it can be very difficult, but I think all you can do, establish the facts with your client, make sure there isn't anything that they haven't told you, get the revenue to put their position as to why they think it's deliberate or careless when they're making a discovery, and then you need to start chipping away at it. But unfortunately, there are some very reasonable inspectors out there, but unfortunately I do come across cases where the inspectors become a bit intransigent, and they've dug their heels in, and no matter what you say, they're not going to change their mind. So in those circumstances, getting somebody else on board, presenting the case in the facts in a slightly different way, that may help to break the deadlock. Because if you're going to go off to the tribunal to get justice, then it's going to get very expensive. I appreciate that's quite a long-winded answer, Kevin, but and Keith who asked the question, but it's an extremely important question, and hopefully that's of some use.
Okay, great, thank you. When you say one of two conditions is to be met, are you saying that careless behaviour allows a discovery, even if the officer could reasonably be expected to have identified the issue from the information available at the time?
I mean, if the tax return was made on the basis of the prevailing practice, then and the taxpayer can demonstrate that, then the revenue cannot make a discovery. Where if the return was made on the basis of the prevailing practice.
Yeah, I think the question moreover was if you put something in the white space box, for example, making a disclosure,
yes,
and it's a full disclosure, even if it's careless or deliberate, then can the revenue still assess the tax?
I mean, if you've made the suitable white space entry, before you get on to the consideration of careless or deliberate, you need to establish whether or not the revenue have made a discovery. And if the facts of the case are that sufficient disclosure was made in the white space, the revenue cannot make a discovery, because
okay.
the starting point in the process in terms of the checklist, have the revenue made a discovery, if sufficient disclosure has been made, and I appreciate that could be a debatable point, but if suitable disclosure has been made, the revenue cannot make a discovery.
Okay, that's great. Okay, if you lead on, we have some more, but I'll ask them a little bit later.
Great. Okay, thank you very much, Kevin, and thank you for those questions. In terms of a history of disclosure, I've put some cases on the slide. I've only gone back to 1962. There are some that predate that, but certainly when I started as an inspector, and it wasn't as far back as 1962, I hasten to add. Senlon and Olin were the key cases on discovery, and for a long time, as I say, they were the default cases, and the conditions for the revenue to be able to make a discovery assessment were well known, and I think broadly understood. And there were relatively, or the commissioners who were the predecessors to the tribunal were sort of rarely troubled by the issue of discovery or Section 29. I think that changed with the introduction of self-assessment and an overhaul of Section 29 to restrict the revenue use of discovery, and that changed the position. And over the last sort of 20 or so years, there have been a significant number of cases looking at discovery or discrete parts of discovery. Some of them have gone in favour of the revenue, some of them have gone in favour of the taxpayer, sometimes on almost the same facts. So there is a huge amount of case law out there, and the Veltimer case, which I've referenced on the slide, that first gave the concept of a hypothetical officer when the revenue are considering, as at subsection 5 of Section 29, the information that's been provided to the revenue and the sufficiency of that information. The Veltimer case gave us the concept of a hypothetical officer, and was there enough information there for the hypothetical officer to consider whether or not a discovery had been made, and there was an insufficiency of tax. Another important case in the progress of case law on discovery was the Corbley-Staunton case, and that was the first one to consider the concept of staleness. So at the start, I referenced the time limits that the revenue have to make a discovery assessment. And what was introduced in Veltimer and followed up in subsequent cases was whether the revenue, once they've made a discovery, whether they had to raise an assessment within a certain period of time after making that discovery, or whether after making a discovery, if the revenue didn't do anything within a certain period of time, the discovery was stale and the revenue could no longer issue a discovery assessment. And what the Charlton case brought to the table was that there wasn't a need for any new information of fact or law for there to be a discovery. The only requirement was that it had newly appeared to an officer acting honestly and reasonably, that there was an insufficiency in an assessment, and that included change of view or change of opinion.
We have a quick question here on the case law. Sorry, it's from Sabir. Thank you, Sabir. How do you deal with officers who do not understand the rules of discovery, let alone the case law?
Well, another good question. I'm sure that's one that many others on the webinar can relate to. And the answer is, I think it can be very difficult. I would much rather deal with a proficient, knowledgeable, practical inspector than someone who is lacking in the technical knowledge and skills. At least with the former type of inspector, you can either get to a point of agreement or disagreement fairly easily and quickly, maybe, and you can then move on and pursue your options from there. Where there is an issue with the inspector, and what tends to happen is where the inspector maybe is a bit out of their depth, then you can't particularly engage, and they just seem to ask loads of questions, most of which are not relevant. And I think what you can do is, once you've set out your position, and if you really are struggling to get through to the inspector, I think you need to get the case looked at by somebody else and get the matter referred to the inspector's manager. Not necessarily going to mean that the inspector is going to be taken off the case, but they may perhaps be given some assistance or encouraged to speak to one of their colleagues and get the appropriate technical assistance, because otherwise you are just banging your head against a brick wall. I had that on a case recently, and I was given the correspondence, and it's fair to say that mistakes have been made on both sides, and I suspect that the accountant was probably in a similar position. There were a number of technical points that have been overlooked or not considered. The inspector was very much of the type that you referenced, Sabir. So when I got involved, I submitted a lengthy letter to the revenue, to the inspector, and the outcome of that was about a week later, I got a call from another inspector who acknowledged the difficulties, but after that, the matter proceeded in a satisfactory fashion. So you need to get somebody else from the revenue involved, whether that's the person's manager, whether it's reference to someone in one of the revenue specialist units, to break the deadlock, because otherwise you are just not going to make any progress at all. As I say, in that case, I sent a letter in, and knowing that will be passed up the food chain, if I can use that term, and that certainly had the desired effects. I think it's just a question of plugging away, making those representations, and if you reach that point where the inspector just isn't getting it and isn't engaging, then you need to escalate the matter accordingly, and that can be done in a way that doesn't insult or aggravate the officer.
Okay,
any other questions at this stage?
No, we've got more that are along the lines of case studies that I'll come to a bit later on.
Right. Okay, then that's great. I shall crack on, Ed. Thanks. So and I'll just cover these cases, just provide a brief comment. The Freeman case, that concerned the application of particular subsections of section 29, and in that case it was determined that the disclosure that was made on the return in the white space, which I referenced earlier, was not deemed sufficient, but because information had been provided to the revenue in the course of an earlier inquiry, that was sufficient to tick that particular box. In the Sanderson case, that also made reference to the status of the hypothetical officer, and even if the officer involved in the case has the knowledge they require to raise an inquiry, it's not his knowledge that's relevant. It's that reasonable hypothetical officer that needs to be taken into account for the purposes of Sanderson. The Patillo and Beagles case, they both concerned staleness, and in the Patillo case, the upper tribunal accepted that HMRC were required to make an assessment immediately upon making a discovery, and in the Beagle case, the revenue had missed the deadline to open an inquiry into Mr. Beagle's return, and there was a delay of 2.5 years in issuing an assessment, and that was deemed to be too long, and the discovery had become stale. So just when it was starting to look good for taxpayers, we had the Tooth case, and this was extremely significant on a number of levels. The case, and I suspect it's a case that many on the call will be familiar with, but I think it's worth certainly considering briefly here. In the case of Mr. Raymond Tooth, information had been disclosed in the tax return in the wrong box, but an explanation was provided in the white space. The first tier tribunal determined that there was a discovery in 2014 and that Mr. Tooth had not made a deliberate discovery. When the case went to the upper tribunal, the decision there was that there was a discovery, but it was made in 2009, and that discovery had become stale by 2014, and the new inspector in 2014 couldn't make the same discovery as the one made in 2009. When the case got to the Court of Appeal, the judges there agreed with the upper tribunal on discovery. They found that there was a deliberate inaccuracy, but they agreed that the discovery was stale. When the case reached the Supreme Court early in 2021, the judges there decided, or when they reached their decision, they went back to the first tier tribunal. The discovery was made in 2014. There wasn't a discovery, never mind a deliberate discovery, and they took the view that when considering whether or not a discovery has been made and where you've got a tax return, you have to look at that tax return as a whole, as you would do with any other document. And the Supreme Court dismissed HMRC's appeal. Now, as there wasn't an inaccuracy in the return, the judges didn't need to consider the concept of staleness. However, the judges did take the opportunity to voice their views on the concept of staleness, as the point had been argued before them, but they ruled that staleness did not exist. Their view was there isn't any basis for a time restriction. The provisions of Section 29 already contain time limits, and there wasn't any basis for any further restriction. So the Tooth case, given the circumstances and given the views expressed by the judges of an argued out point, that effectively brings an end to any similar contentions on the point of staleness in other cases. The case was also important for other reasons, including that inaccuracy, and that was looking at the point of deliberate, and the view there by the judges was that an inaccuracy is only deliberate if there is an intention to mislead HMRC or possibly recklessness as to whether HMRC could be misled. So it's a considerably raised bar above that relating to careless behaviour and requiring an element of dishonesty. And I'm sure in a lot of the cases, and certainly with a questioner earlier, whether revenue are contending deliberate, I suspect in a lot of those cases, the revenue would not be able to establish the behaviour of the taxpayer to the high bar that was set in the Tooth case. But we'll come back and pick up some other points relating to other cases in a few minutes post Tooth, because you would think that with the Supreme Court laying down their views on staleness, certainly that's the position that the revenue are going to be very happy to accept. And in relation to the comments on deliberate behaviour, you would like to think that the revenue would take those on board, and we'll look at some cases in a few minutes where perhaps that isn't what the revenue have done. The Carter case involved a husband and wife, and it's a stamp duty SDLT case, and the provisions there are the same as contained at section 9, and the taxpayers entered into an SDLT avoidance scheme. There was a disclosure made on the tax return, not that they'd used the scheme, but certainly reference was made to some of the impact of the scheme. The revenue didn't make an inquiry, but they did subsequently raise a discovery assessment, and the first tier tribunal determined that an officer of HMRC could not be reasonably aware of the insufficiency, and the discovery assessment was held to be valid. But this takes us back to the point of how much information do you need to include when making a white space comment on the return, and certainly in the Carter case, the point there was that they hadn't. The case went to the upper tribunal. They had to decide if the first tier tribunal had erred in law, and the outcome was that the first tier tribunal was upheld. and an important point there is, if the case had just sat with the first tier tribunal, it doesn't set a precedent, but the case has been heard by the upper tribunal, and the ruling there was that the disclosure on the return was inadequate. It didn't give, although there was quite a lot of detail included on the return, it was deemed not to be sufficient, and it didn't provide an analysis excuse me, of why the relevant provision would not apply. So it significantly raises the bar in terms of what needs to be put on the return, and it's almost, you need to put sufficient information on the return such that the revenue, if they look in the box, they will have to raise an inquiry into the return, because that was the feeling coming out of this particular case, and the level of detail that would be needed. So I'm sure that is, we certainly haven't heard the end of cases coming before the courts dealing with discovery. Say the last 10+ years, there've been a lot of cases considering staleness, and I think the issues coming out of this case are going to cause problems. Are going to cause problems for a lot of taxpayers, because the bar is set incredibly high now, based on this decision, as to what needs to be included to give adequate protection against the revenue being able to make a discovery assessment. All very sobering for a Wednesday early afternoon. However, this case was had a better outcome for the taxpayer. Caroline Sweeby had entered into a tax avoidance scheme. She was one of many that had used a particular scheme, and the revenue issued a discovery assessment. They delayed dealing with the case pending resolution of hearings in cases for other users of the avoidance scheme. They didn't submit a statement of case. They missed the deadline. They didn't request an extension for submitting a statement of case. And when the other cases had sort of settled, the revenue contacted the agent's representative, and when the agent pointed out to the revenue, "You're too late," it still took the revenue a further 5 months before they submitted a statement of case together with a request that the late submission be accepted. And overall, the delay in submitting the statement of case was the tribunal spelt it out very clearly, was more than 3 years and 2 months. The Revenue tried to excuse it. The delay had been caused by an administrative error, or I suspect a series of administrative errors, and the application for an extension to provide a statement of case was refused, and consequently the taxpayer's appeal was allowed. And I think the point here is that if the case had gone to a hearing, the taxpayer may well have lost the substantive argument, but because the Revenue hadn't dealt with the administration correctly, the taxpayer's appeal was allowed. So when you're dealing with discovery, you know, we've mentioned some of the technical issues in terms of the behaviour and the level of disclosure that's made on a tax return, but it's also incredibly important to be aware of the procedural side as well. And as was the case here, if the Revenue don't do what they should have done by the time when they should have done it, then and the excuses that the Revenue came out with, the tribunal weren't having any of it. So it's important to look at the procedural and administration aspects when you're dealing with a discovery case, just as much as the technical considerations as well. Some more recent cases. The McComiskey case. This was one, and it looked at the issue around a person acting on the taxpayer's behalf, and for this, the tribunal went to the law of agency. The taxpayer had submitted appointed an agent. Unbeknown to him, the agent had delegated to a sub-agent without the taxpayer's authority. A return had been submitted with a false claim for relief. The repayment was made by the Revenue directly to the sub-agent, because that was what the sub-agent had put on the return. And when all the facts unfolded, the taxpayer was going through a pretty tough personal time. Not that that's relevant to the outcome of the case, but the tribunal saw that accepted that the taxpayer wasn't aware that those claims had been made. They agreed that the sub-agent had been appointed without the taxpayer's authority. That person was therefore not acting on the taxpayer's behalf, and the appeal was allowed. And when commenting on the case, the tribunal noted that it was a consequence of the Revenue's policy of process now and check later, which meant that the repayment had been made before the tax return was checked. And because of the particular details that were put on the return, and I won't go through those now because of time reasons, but have a look at the case and you'll see that, you know, previously, if the Revenue had, you know, even glanced at some of the other entries on the return, they would have realised that it didn't make any sense, and they would not have made the repayment. So in that case, the taxpayer's appeal was allowed. In the case of Dugan, the taxpayer there, he was involved in the music industry and also purchased a vineyard as well. Had a history of not sending tax returns in for many years, but then sending them in on bulk and eventually paying the tax. And the Revenue contended deliberate behaviour. And when they were arguing the point, they weren't going by the comments in the tooth case. They were looking at the less serious view that was taken in a case called Klein's, where the point there was that the revenue argued in this case that the taxpayer had made a conscious decision not to complete his returns, rather than asking whether this was prompted by an intention to bring about a loss of tax. The evidence in the Dugan case was that Mr. Dugan didn't think that he was ultimately failing to pay the tax due. There was a history, as I say, where he didn't submit his tax returns for several years. Then he'd send them in and he'd pay any tax that was due. And the first tier tribunal held that there wasn't any intention to bring about a loss of tax. So lots to consider there. And certainly as far as case law is concerned, then we're going to be seeing case law on discovery for a very long time to come, particularly if the revenue are going to be taking the approaches that they took in Dugan when it comes to deliberate behaviour. I'm going to finish off by going through some practical considerations. And as I said at the start, it's important when the revenue are making an allegation of discovery that you establish the facts. And even if you've spoken to the client before, sit down with them, go through all of the issues, all of the areas. Is there anything they haven't told you about? So that before you go back to the revenue, you know exactly where you're coming from. That's the position I always take. Before I have any meaningful engagement with the revenue, then I want to know that I'm on solid ground, or if not, then exactly how solid the ground is. And you can only do that by going through with the client to establish all of the facts, all of those factors that I mentioned at the start of the session in terms of what's happened and when, if mistakes have been made, why, was any advice taken? If so, who from? Is that advice that the client can rely on? You then need to consider each aspect of the discovery provisions, because what tends to happen, and those of you that will have seen these cases will probably have seen this as well, what tends to happen is that the revenue will write out and they will say, I think your client's there's an insufficiency of tax, here's my discovery assessment, and they don't go into any detail. And a mere suspicion that an assessment is insufficient is not grounds for the revenue to make a discovery. So you need to try and find out what is it that the revenue are contending. You need to consider each aspect of the discovery provisions. I mentioned about the careless and deliberate, and we covered that point earlier. Absent an admission by the client, the onus is on the revenue. What disclosure was made on the tax return, if any, what other information has been provided to the revenue, and bear in mind that the burden of proof to establish a discovery is with the revenue, and the first thing to do is to write back to the revenue, ask them to justify why they think they've made a discovery, on what grounds, which one of the conditions at 29.4 or 29.5 do they think applies, on what basis do they think the behaviour is either careless or deliberate. Now, the chances are when the revenue write back, they're not going to answer those questions, and they're not obliged to. There isn't anything that requires them to provide that information when they make the discovery assessment. However, it's all going to come out at some point at the tribunal if it gets that far. But it certainly doesn't do any harm to ask the revenue to put their case down and put their points down on paper, so that you can then go through those with the client. And as I just said in a few minutes ago, do check for procedural and administrative errors by the revenue. We touched briefly on the prevailing practice. There, the burden of proof switches to the taxpayer, and it's important that you retain evidence of any guidance that's used when completing the tax return. The revenue do have a habit of issuing protective assessments, so they're coming up to the 6-year time limit for raising an assessment, and they will write out and say we're making a protective assessment. There isn't any such thing. Either the revenue have made a discovery or they haven't. So if the revenue raise assessments on that basis, you need to make sure that you're challenging the issues of those assessments. The mere fact that a time limit is expiring doesn't give the revenue the right to issue an assessment. And just the final point to finish up on, frequently where you get discovery, you get an inquiry from the revenue into return, they will say that they've established irregularities. They will use the presumption of continuity to say that, well, if you've made an error in 2018, you also made the error in 2017, 2016, 2015, and so on, and also later years. And the reference case there was Jonas Banford, no longer referred to by the revenue, but the Sterling case showed that the revenue need to look at the facts of the case, and they can't automatically presume that there is a continuity of whatever has gone wrong, and the revenue have now reflected that in their manual, and I've included the reference on the slide. So if the revenue do allege presumption of continuity, that's certainly one that you need to go back on and demonstrate to the revenue what changes there have been to the client's business, and maybe the entire nature of their business has changed. I'm very conscious of the time. Thank you very much for listening. I'll hand back to you, Kevin.
Okay, thank you. We've got a number of questions to get through, small number. Does the discovery concept have any relevance where HMRC issue a counteraction notice under section 698 ITA 2007?
I am going to pass on that one for the moment, Kevin. Can you
Okay.
just give me that, what section number was that that was being referred to in the query?
Section 698 ITA 2007.
ITA 2007. Okay, I'll check that point. That's not a particular point that I've come across, but I'm happy to look into that and go back to the questioner via you if you're happy to do so, Kevin.
Yeah, that's fine. Yeah. Is it necessary to actually quantify the amount of tax which is at stake if HMRC don't agree with the treatment used?
If HMRC don't agree with the treatment used, presumably this is in relation to the disclosure on the tax return. Yep. Certainly for the revenue to make a discovery, they need to establish that there's been an insufficiency of tax. So the answer to the query is going to depend on the information that's in the white space. If it is clear from the note in the white space what the potential insufficiency is, that should help to protect against the discovery rather than leaving out any quantification of the liability that may be in dispute.
We have a query on the tooth case. Isn't the Supreme Court comment in tooth re staleness only obiter and not part of the ratio descendente, so not binding in future? I don't know that's the pronunciation, but
yeah, absolutely. Well, and again, a very good point. It was only the view of the judges, but I think the issue there is that given that the judges, the point was argued before the judges, and they've given their view in very strong terms, then whether if the matter got to the Supreme Court again, judges would come to a different decision given the very strong views relayed by the decision in the tooth case. Then I suspect that that they would come to the same decision. So absolutely, it's not binding in the way that other decisions are, but because of how the judges have come to their decision, the fact that it was argued before them and they've given a considered view, then I think to all intents and purposes, I think to try and argue on staleness, you're probably on a losing battle. And certainly I would not want to take a case to the tribunal where you were solely relying on the concept of staleness. You would want to look at other aspects of discovery to see whether you've got something a bit more solid than staleness, which would be, in view of the comments in the Tooth decision, would be very shaky ground, I would suggest.
Okay, thank you. Susan asks, we have an ongoing inquiry whether the director has used company money for private purposes and not taken care to ensure the costs were coded appropriately in the accounts, easy to reallocate to the director's loan account. Mitigating factors were the director suffered from alcoholism during the period of inquiry. Do you think there's a chance HMRC can be persuaded this was not careless or deliberate?
A good question, and I think the answer there is that I think you'd need more of the facts around the case to know whether or not you could construct a case. Why was it that it wasn't done? Are they saying that it was purely the client's alcoholism? I think you would want to look at any medical evidence to support that, any treatment that the client was having. I think you'd want to look at, to what extent they were able to conduct other aspects of their lives, and then sort of, decide on that the strength of the case. So potentially it could be, but I would want a bit more detail before I would be able to offer any perhaps more positive words of encouragement on that. But it's certainly something that could be looked at. And when I tend to get involved, often I will sit down with a client and there are 50 questions I come up with that the accountant hasn't asked. And when you dig a bit deeper and get some more of the surrounding information, there may be more of a case than is at first apparent.
Okay, I'd only add to that, Susan. I've seen the case here at PFP where alcoholism was successfully argued as an excuse or a reason. Okay, a question from Gordon. Client filed a 2011-12 tax return. HMRC has recently asked for information regarding a disposal of shares not reported, where the client was not the beneficial owner, i.e., so the return was correct and there has been no careless or deliberate behaviour. Does the client have to cooperate with the information requested?
So the revenue are asking for information regarding a disposal that relates to 2011-12, but they weren't the beneficial.
Yes.
Holder. So are the revenue, do you know, Kevin, sorry, whether the revenue are alleging that they've made any sort of discovery?
They are saying they've discovered a disposal of shares.
Okay, well, I think there, given that the time that we're talking about, the revenue would need to be contending that there was deliberate behaviour by the taxpayer or someone acting on their behalf. So I think before providing any information to the revenue, you would want to go back to the revenue to query the basis on which they're making they claim to be making a discovery. And what I would also do is I would go back to the client just to double check the facts, just to make sure that there aren't, to establish whether or not there are any implications for the client.
Okay. Lastly from Musaddiq, I have a high net worth client, non-dom, and has been in the UK for less than 3 years. He's been filing tax returns on a remittance basis. He had a letter from HMRC to say if he would like to speak to the inspector for completing and filing his tax return for 21-2. Do you think our client should talk to the inspector, or is the revenue fishing for information from him? He's been declaring his UK income and paying tax on this income. None of the overseas income has been remitted.
Well, I think that's a very kind request, and it's nice to see that the revenue got time to offer to speak to taxpayers. Under no circumstances would I suggest that any of my clients speak directly to the revenue. So I think it will be a very polite decline to that request.
Okay, thank you very much.
The only point I would make there, though, is that if it's the agent ringing, then they may want to, ring and engage with the inspector. I would advocate that potentially, but I certainly wouldn't be saying to any of my clients, and I say to all of them, they should not engage directly with the revenue, no matter how well-meaning the revenue's intentions may appear to them to be.
Okay, great. Thank you very much. Okay, well, thank you all for listening. I know a number of you have kept on, even though we've gone 5 minutes over time. Thank you again, Phil, for a very informative and detailed presentation. We covered quite a lot of ground in there, which I hope everybody's, at least get some practical use out of. This is one of our monthly webinars for member firms and selected guests. So thank you for listening. We will have another webinar next month, and we'll receive details in due course. If anybody has any questions they'd like to ask, then please send them in, and we'll get them dealt with in the usual way. So thank you again for listening, and thank you, Phil. If you'd like to say a quick goodbye, we'll end it there.
Thank you very much, Keith. Thank you very much, everyone else, for listening. My email is on that last slide, so if anyone has any queries that they want to send to me directly, I'll be very, very happy to deal with them. Thank you very much for listening. Thank you, Kevin.
Cheers then. Bye bye all. Thanks for listening.